1 minute ago, Tuesday, February 10th, 2026, Donald Trump broke his silence. But here is the thing about silence in the legal world. It is never just silence. In politics, silence can be strategy. In media, silence can be suspense. But in court, silence can mean noncompliance. And noncompliance is the precise moment when judges stop waiting and start ordering. At 8:04 a.m. Eastern. A clerk's notice quietly posted to the docket of the United States District Court for the Eastern District of Manhattan. It scheduled an emergency compliance status conference for 1:30 p.m. that same day. No dramatic language, no flashing lights, just procedural movement. But anyone who understands federal court rhythm knows what that means. When a judge moves same day, something has shifted. 7 minutes later, at 8:11 a.m., a sealed attachment was partially unsealed. Not the contents, not the evidence, just the exhibit index. And sometimes the index is enough. It tells you what kind of fight is coming. At 8:18 a.m., the defense filed a short letter asking for more time. 8 minutes after that, at 8:26 a.m., the judge denied the request in a single paragraph minute order and kept the emergency conference on calendar. No delay, no extension, no cushion. Then, at 8:33 a.m., Donald Trump posted his first direct public statement in 48 hours. That is the clip everyone will run. That is the headline cable will loop. But it is not the lead. The lead is what the court did before he spoke. Because when the court moves first, your statement is no longer the story. It is the reaction. Let me give you the timeline that matters, because this entire episode hangs on it. Friday, a compliance directive is issued with a firm deadline. Saturday, the defense signals it cannot meet that deadline as written. Sunday, internal family messaging fractures, and there is no unified public posture. Monday night, the moving party files a notice of noncompliance and requests immediate enforcement. Tuesday morning, the judge schedules an emergency conference and orders personal appearances. 3 days. That is all it took for this to move from manageable to urgent. And in this dramatized scenario, the pressure point is simple. Ivanka Trump is facing a court-imposed deadline tied to surrender, production, or sworn certification. The exact procedural mechanism almost does not matter. The framing from the court is the same either way. You were ordered, you were warned, you were given time, and now the clock has expired. This is where the family rift becomes more than tabloid material. In high-profile litigation, coordinated behavior is everything. The legal plan depends on discipline, unified messaging, precise timing. When the family cannot coordinate the message, they often cannot coordinate compliance. And judges can sense that faster than social media ever could. In this fictional posture, Ivanka is a defendant in a high-visibility matter blending alleged financial conduct with procedural obligations. Donald Trump is both political force and family patriarch, whose public statements ripple through the ecosystem surrounding the case. And the court has reached the point where it is no longer interested in assurances. It wants proof, not promises, not posture. Proof. Here is why the phrase Trump breaks silence works in this framework. The audience assumes silence meant strategy, but the docket suggests silence meant uncertainty. And in court, uncertainty triggers acceleration. Because Monday night, the moving party files a notice attaching a compliance log and claiming the defense missed a deadline without timely seeking relief. That single claim shifts posture from patience to enforcement. Let us walk through the fictional packet the way seasoned legal observers do. Document 1. Notice of noncompliance. It is clinical. Order issued on date A deadline set for date B. Reminders sent on date C. No completion received by date D. It reads like math. No adjectives. Just sequence. Document 2. Request for immediate enforcement. Here, the moving party asks the court to act now. Bench directive, modified conditions, sworn certification, same-day conference. The message is clear. Delay increases risk. Document 3. Exhibit index. Proof of service confirmations, communications logs, travel summaries, device custody forms, a declaration from a records custodian, the bones of accountability. But then there is the human wrinkle. The packet references what it calls a family witness posture issue. It does not allege a crime. It implies distance. A close family member was approached to help mitigate consequences and either declined or did not provide helpful testimony. That distance becomes legally relevant because courts do not care about family drama. They care about signals of reliability or risk. The moving party argues that internal distance suggests instability. That instability suggests compliance risk. And compliance risk triggers enforcement tools. That is how something personal becomes procedural overnight. Now, here is the turn nobody saw coming. It is not that a deadline existed. It is that the defense apparently assumed it could be managed quietly, while the moving party treated it as a hard line. And the judge sided with the hard line by moving fast. The minute order Tuesday morning uses language judges deploy when negotiation is over, the court requires immediate clarification. The parties shall appear. Failure to comply may result in enforcement remedies. That tone shift is everything, and Trump sensed it. At 8:33 a.m., he posts. He calls the process unfair. He calls the pressure political. He insists his daughter will be vindicated. He attacks the system. It is offense. It is forceful. It is familiar. But courts do not respond to offense. They respond to compliance. And here is the second complication. Public escalation hours before an emergency conference makes it harder for a judge to keep proceedings narrow. Judges prefer procedural rooms, not political theaters. When the temperature rises outside, the instinct inside often becomes tighter control to preserve process integrity. The defense's letter argues that compliance is underway, that enforcement would be disproportionate, that timing is being weaponized. The moving party counters that informal flexibility is not a legal mechanism. Only the court can extend deadlines. If you need more time, you file a motion. If you do not file it, you do not have it. That procedural fact does not bend for politics. So we move to 1:30 p.m. Judge Elena Marquez opens the emergency conference with a single binary question. Was the deadline met? Yes or no? Defense counsel begins context. The judge interrupts. Yes or no? Narrative collapses into answer. The defense concedes partial noncompliance, but argues good faith and imminent completion. The moving party responds that partial noncompliance is still noncompliance. That is the hinge moment. The judge does not rule on guilt. She signals control. She orders a sworn certification within 24 hours. She orders completion of specified compliance items by close of business within 48 hours. She schedules a follow-up for Thursday morning and warns that if unsatisfied, the court will consider expanded enforcement remedies. That is the move. From voluntary compliance, expected to compliance, verify. Experts would tell you this is the pivot stage. A former prosecutor would say deadlines are the fastest trigger for enforcement. A defense attorney would warn that public statements can box in legal posture. A former marshal would note that once noncompliance is formally recognized, the system becomes procedural and mechanical. A constitutional scholar would remind you that courts guard process above all else. And here is why this matters beyond the headline. When courts tighten compliance posture for powerful defendants, baseline expectations shift. Other judges become less willing to grant informal flexibility. Prosecutors cite high-profile noncompliance to argue for stricter conditions elsewhere. Process culture changes quietly, but it changes. Now return to the rift. The packet's reference to a close family member declining to provide helpful mitigation testimony becomes a subtle lever. It is not proof of wrongdoing. It is evidence of seriousness. Judges listen to witness posture because it speaks to credibility. If your closest circle does not publicly vouch for reliability, the court asks why. Trump's statement attempts to restore unity perception, but perception does not satisfy deadlines. Sworn certifications do. And certifications are dangerous terrain. Too broad, and you risk later contradiction. Too narrow, and you signal incomplete compliance. Precision takes time. But the judge is moving quickly. That is the squeeze. As Tuesday closes, 3 deadlines loom. 24 hours for sworn certification, 48 hours for completion of remaining compliance items. Thursday morning, follow-up conference with explicit warning of potential expanded enforcement. The political cliffhanger is separate but intertwined. If Trump's public offense is cited as evidence of defiance or instability, it could justify tightening conditions further. Public litigation carries risk. Courts prefer paper over rhetoric. So where are we right now? Ivanka has hit a court deadline. The moving party claims noncompliance. Trump has broken silence. The judge has signaled acceleration. The family rift has shifted from private tension to procedural factor. It changed overnight because deadlines are the hidden engine of legal drama. Not speeches, not rallies, deadlines. And what happens next depends not on the loudest statement, but on the next filing. Whether the sworn certification lands clean and complete, whether the follow-up order stabilizes this into routine compliance, or whether the court decides it no longer trusts voluntary behavior and moves into enforcement posture. That is the difference between a headline and a turning point. Thursday morning arrives without spectacle, which in federal court is usually a bad sign for the party under pressure. There are no leaks overnight suggesting a breakthrough, no triumphant statement from the defense, no quiet notice of completed compliance posted to the docket at 2 a.m. Instead, at 7:12 a.m., a supplemental filing appears. It is labeled Sworn Certification of Compliance Partial. That single word, partial, lands heavier than any press conference ever could. The certification is signed. It is notarized. It is careful. It confirms that certain requested materials have been produced, that certain obligations have been satisfied, that certain representations are true to the best of declarant's knowledge. But it also references ongoing review, continuing production, and technical impediments outside declarant's immediate control. Those phrases are oxygen to a defense team trying to buy time. They are gasoline to a moving party arguing non-compliance. By 8:03 a.m., the moving party files a response. It is not long. It does not need to be. It quotes the judge's own minute order back to her. Full compliance within 48 hours. It underlines the word full. It attaches a side-by-side chart comparing the order's requirements with what has been produced. There are check marks in some boxes, there are blank spaces in others, and blank space in a compliance chart is a problem. The courtroom at 10 a.m. is quiet in the way rooms get quiet before something procedural but consequential happens. No cameras, no dramatic outbursts, just lawyers at tables and a judge who has already read everything. Judge Elena Marquez does not begin with commentary. She begins with math. Counsel, she says evenly. The court ordered completion. Has completion occurred? Defense counsel stands. He speaks in measured tones about substantial compliance, good faith efforts, logistical challenges, ongoing production. The judge listens. Then she asks again, has completion occurred? It is remarkable how often litigation collapses into that kind of simplicity. The answer, eventually, is no, not fully. What follows is not theatrical. It is procedural, and procedure is often more devastating than spectacle. The judge notes that the court's authority depends on enforceable orders. She notes that flexibility was offered. She notes that deadlines were clear. She does not raise her voice. She does not threaten. She simply states that when orders are not met, the court must consider remedies designed not to punish, but to compel. That distinction matters legally. Compel, not punish. The moving party requests graduated enforcement, daily monetary sanctions until completion, an order requiring third-party supervision of remaining compliance tasks, and a requirement that the declarant appear in person at the next status conference. They frame it as necessary oversight, not escalation. They emphasize that compliance culture, once eroded, must be restored through structure. Defense counsel argues proportionality. He warns that monetary sanctions would be portrayed publicly as political retribution. He suggests that third-party supervision implies distrust inconsistent with the defendant's history of cooperation. He urges patience. He promises completion within days. But here is the quiet shift that has been building all week. The court is no longer reacting to promises. It is reacting to missed deadline. And the more public the promises have been, the less the court can afford to let them substitute for performance. Judge Marquez pauses. She looks down at the chart with blank spaces. And then she does something subtle, but decisive. She reframes the issue. This court does not respond to public narrative, she says. It responds to compliance. In that sentence, the political temperature drops out of the room. There will be no debate about fairness in the abstract. There will be no weighing of media commentary. There is only the order and whether it has been obeyed. The ruling comes in layers. First, the court finds that the defendant has not fully complied with the prior order within the specified time frame. That finding is narrow. It is factual. It avoids adjectives. Second, the court imposes a daily compliance sanction, a fixed monetary amount accruing each day until full compliance is certified and verified. Not retroactive, not astronomical, but enough to create urgency. The judge explains that the sanction is coercive, not punitive. It will cease the moment compliance is complete. Third, the court orders a third-party compliance monitor, limited in scope to the outstanding items identified in the chart. The monitor will verify completion and file a brief report directly with the court. The defense objects to the symbolism. The judge responds that symbolism is irrelevant, verification is the goal. Fourth, the court schedules a personal appearance for Ivanka Trump at the next status conference. Not for testimony on the merits, not for cross-examination. For accountability on compliance. The judge emphasizes that when a sworn certification bears a name, that name may be called to answer questions about it. And then, almost as an afterthought, the court addresses the public statements. Without referencing any specific post, the judge notes that commentary outside the courtroom has no bearing on the court's enforcement of its orders. However, she adds that attempts to litigate compliance in the media risk misunderstanding the nature of judicial authority. Orders are not suggestions. Deadlines are not aspirational. The gavel does not bang. Federal judges rarely use them. The hearing adjourned. Within minutes, the ruling spreads. Headlines focus on sanctions. Commentators focus on the personal appearance order. Supporters call it overreach. Critics call it inevitable. But the most significant development is quieter. The system has moved from trust-based compliance to supervised compliance. That transition is hard to reverse. Back at the defense table, the strategy recalibrates. The cost of daily sanctions accumulates not only in dollars, but in narrative weight. Each day of non-compliance becomes a clock visible to the public. The compliance monitor's involvement limits flexibility. There will be no creative interpretations of substantial. There will be checklists. Inside the family dynamic, pressure intensifies. Public unity statements now intersect with sworn obligations. The certification language to the best of declarant's knowledge may soon be probed in open court. Precision matters. So does consistency. By late afternoon, a new filing appears. Notice of accelerated completion. It attaches additional documents. It confirms overnight work. It signals that remaining items will be finalized within 24 hours. The tone has changed. It is no longer about fairness. It is about finishing. The compliance monitor files an initial report the next day. Several outstanding items have been completed, 2 remain, technical explanations are provided, deadlines are proposed. The monitor recommends continued oversight until verification is total. And here is the moment that shifts everything. At the next status conference, Ivanka Trump appears in person. The courtroom is again quiet. The judge addresses her directly but respectfully. "You signed the certification," she says. "Do you stand by it?" "Yes, Your Honor." "Are you aware of any outstanding materials within your control that have not been produced?" A pause. It is brief, but in a courtroom, second stretch. "No, Your Honor." The compliance monitor confirms that, as of that morning, all previously identified items have been produced and verified. The blank spaces in the chart are gone. Every box is checked. Judge Marquez reviews the updated report. She turns to the moving party. "Do you dispute completion?" After conferring, the moving party concedes that, based on current verification, compliance is complete. The daily sanction is lifted effective immediately. The third-party monitor's mandate is terminated upon filing of a final confirmation. The personal appearance requirement is deemed satisfied. The court reminds all parties that future deadlines will be treated with equal seriousness. And then, in a line that will not make the loudest headlines but may matter the most, the judge states, "The authority of this court is not political. It is procedural. Compliance preserves liberty. Non-compliance risks it." The hearing ends. Outside, reactions are predictable. Some frame the episode as proof of persecution. Others frame it as proof that no one is above court orders. But beneath the noise, something more structural has happened. A high-profile defendant missed a deadline. The court responded not with fury, but with structure. Sanctions were imposed. Oversight was ordered. Personal accountability was required. Compliance was achieved. Sanctions were lifted. It is almost anticlimactic. And that is the point. The shock was not a dramatic arrest. It was not a sweeping indictment on new charges. It was not a family member testifying against another. The shock was procedural inevitability. The realization that when the system decides to enforce its own timeline, rhetoric cannot slow it down. In the days that follow, analysts debate whether the initial non-compliance was strategic miscalculation or logistical failure. Legal scholars write about the increasing willingness of courts to move quickly in high-visibility cases. Former judges note that public attacks on the process often accelerate enforcement rather than deter it. Political operatives spin narratives, but the docket tells a simpler story. Order issued, deadline set, deadline missed. Enforcement triggered, compliance compelled, sanctions lifted. For Ivanka Trump, the immediate legal crisis stabilizes. There is no expanded enforcement, no contempt finding, no custody order. The episode closes with completion, but the lesson lingers. Deadlines in federal court are not political events. They are mechanical triggers. And once triggered, they move forward with or without public approval. For Donald Trump, breaking silence may have rallied supporters, but it did not alter the court's trajectory. The statement became background noise against the steady hum of procedural authority. The judge neither acknowledged nor reacted to it, beyond reminding everyone that compliance, not commentary, governs outcomes. And for observers watching closely, the real story is institutional. The judiciary demonstrated that it can absorb political heat and still operate on its own timetable. It showed that enforcement can be calibrated firm without spectacle, corrective without collapse. What happens next does not involve fireworks. It involves future deadlines. It involves whether lessons learned translate into smoother compliance going forward. It involves whether public rhetoric continues to collide with private obligation. But the shock everyone expected, the dramatic downfall. The explosive revelation resolves instead into something quieter and, in many ways, more powerful. The rule of procedure holds. The clock matters. And when the clock runs out, even the loudest voices must answer a simple question. Has completion occurred? This time, the answer is yes.